The U.S. Department of Justice is doubling down on False Claims Act enforcement. What do companies doing business with the U.S. government need to know about the evolving FCA enforcement landscape? The False Claims Act is the U.S. government's primary tool to investigate allegations of fraud by government contractors. And from the outset of President Trump's term, the U.S. Department of Justice made clear that it would continue prosecuting False Claims Act cases and defending the constitutionality of its qui tam whistleblower provisions. 2025 was a record-setting year for FCA enforcement, with the highest ever total recoveries at nearly $7 billion and 1,700 new matters. That means 33 new FCA cases were filed every week last year, and that same is expected this year. The Deputy Assistant Attorney General for the commercial branch recently warned that heightened FCA enforcement is, quote, the new normal. What companies need to know is, like those before it, this administration is using the FCA to advance its priorities. DOJ continues to focus on healthcare fraud, cybersecurity, and small business and COVID-19 pandemic programs. It has also introduced new FCA enforcement priorities, such as DEI programs and tariff fraud, signaling an aggressive enforcement shift on both fronts. As to DEI, the government is not waiting for the forthcoming certification that will require all contractors to affirmatively certify compliance with anti-discrimination laws. DOJ has already issued broad subpoenas to dozens of companies and universities investigating their DEI programs and hiring practices. And DOJ is fast-tracking the review of all whistleblower cases alleging discrimination. On the tariff front, DOJ launched a cross-agency trade fraud task force to enforce custom rules using both the FCA and criminal laws. They're focusing on country of origin issues, misclassification of goods, double invoicing, and port shopping. The administration has vowed to regularly use its statutory authority to dismiss meritless FCA cases filed by whistleblowers, which is welcome news for FCA defendants. But even if government dismissals increase, that will likely cover only a small portion of the predicted 1,700 new FCA cases that will be filed this year. It's important to work with counsel to, number one, understand the particular enforcement risks facing your industry and company. Number two, invest in proactive and effective compliance frameworks. And number three, design right-size risk assessments and audits. I'm Ann Robinson, a partner at Latham & Watkins, and I advise clients across industries in FCA investigations, litigation, and compliance. Latham's deep FCA bench brings substantive expertise, government experience, and proven litigation capabilities to help clients manage risk and craft sophisticated legal strategies to successfully resolve FCA matters.